Welcome everyone to our webinar, our Tech Leadership webinar today. My name is Mark Parker. I'm joined on the webinar today by John Anthony from law firm Gadens. Today's topic is around social media and risk management. This is a webinar for JA and I to talk and share with you some thoughts for business leaders, for business owners, and for employers and executives. So we're going to go through a number of topics and incidents today and talk through those. But first of all, today's webinar is brought to you by TEC, the Executive Connection. TEC, as many of you will know, is a leadership network that's part of the global Vistage Group, the world's leading international network of CEOs, entrepreneurs, business owners. In Australia, there's many groups spread around Australia and New Zealand, with around 1,200 business leaders part of this community. And you can find out more about TEC on the web, tec.com.au. I'm very pleased to have John Anthony join me today from Gadens. I'll introduce JA's profile in a couple of seconds. With Gadens are a national law firm, one of our top law firms covering a wide range of business areas and focusing on particularly around some of their special work around supporting the community and the arts. Gadens, more information on Gadens can be found on their website, gadens.com.au. Now today, as I mentioned, I'm joined by John Anthony. John Anthony is a partner with Gadens as part of the employment and safety practice, and he actually heads up that business unit in Brisbane. Welcome, John Anthony. I trust you're having a good day.
For that introduction, Mark.
Excellent. So look, with today's discussion, this is a very topical area, social media and risk management. As John Anthony and I were preparing, I was saying to Jay that over the past 3-4 years, I've had the opportunity to talk to a lot of business leaders on this particular area, and it is an area where business leaders, business owners, CEOs are quite concerned, and I think a lot of their concerns are very valid, because whilst there is a lot of good press around the social media space, there are also some deeper implications and some risks that we all need to be conscious of and have factored into our risk assessments as a business and as an employer. So what we want to do today, as I kick off, is just touch on these couple of quick areas. One, the adoption of social media channels such as Facebook and Twitter, and what this means for employers and how it has increased that risk profile. Both J.A. and I are going to talk about the fact that these risks are real, and as J.A. will share with you, they're real time. This happens, and it's quite often it can not be related to just external forces. So we're going to talk about that. And obviously, a big topic that I often spend a fair bit of time talking about is this whole blurred lines between work and private lives. So do they exist anymore? How do we, as an employer, take action when employees may be doing things what they think is on their own time, their own computers, that may have implications or impact on the business? And I'm sure JA, in fact I know JA has some interesting insights to share there. So, and finally, obviously there are some very interesting judgments and decisions being made now around social media. Is it advertising? Is it social? Is it user-generated content? And what are the responsibilities? So we're going to talk about a couple of case studies in the market. So the key thing, obviously, is that we have a new risk landscape, to coin a term. J.A., from your perspective, what do you see as I guess, some of the key issues coming out now, particularly around the fact that a lot of companies seem to be taking the approach that they're not on social media, so why should they be worried?
Well, I think, Mark, that can I start by making this observation? I was an attendee at a conference recently, and I heard social media likened to sex, and I tend to agree to that observation. The comment made to us at that seminar was that it's pretty easy to get two willing participants, but the social and the legal consequences following it are enormous. And I think if we look very broadly and the view of what's happening out there, we can see that risks are rising in the management of organisations' employment relations with its staff, around disciplinary action when people are inappropriately using social media memes, particularly in the space of Facebook, MySpace and Twitter, to even more significant legal and liability risks around defamation, trademark infringement, copyright infringement, and as many of the listeners may know from following current events reported in the press, Google is currently holding its breath to the High Court to decide whether it has participated in false and misleading and deceptive conduct under the Australian Competition and Consumer Law through the use of its AdWords facility. And we'll probably talk a little bit more about that later. But I have to say, whilst it might seem simple or even trite, the reality is that it's so accessible out there. People have smartphones. Technology is definitely outpacing legal developments in the field, and brand damage and reputational damage probably is the number one issue that I see for organisations in this fast-paced 24-hour, 7-day-a-week world that we now seem to live in.
Yeah, it's a good intro, Jay, and I think the key thing that I always press to organisations is that the point I made earlier, even though you may not, as a company, be active in the social space, you've got to be very, very aware of what's actually happening, because it has snuck up on a number of organisations, and we're going to share some examples about what we're seeing happen and some of the difficulties that arise, and how as an employer, as somebody who might have a position of responsibility, we can actually do some simple things to be organised and be ready. So, and you know, one of the key things we saw recently at JA was this whole Bank West, the CBA Bank West situation. The fact that a high-profile executive within that business suddenly found that they were being impersonated on Twitter, and really turned into quite a disparaging situation for them. And as the CBA found that they, even as a large organisation, they struggle to get their heads around what are the things we actually need to do, and how do we take action on this. Clearly there's, I mean, I'm interested in your perspective. A lot of people think it's grey areas around impersonation, or is it actually a defined attack where there's reputation damage?
Well, in that particular situation, if I can offer a couple of observations. First being CBA, incredibly well-resourced organisation with serious world reach, and despite all of the resources that they had at their disposal, including well-drilled lawyers both here and in the United States, they were simply unable to move fast enough to stop the tweet from continuing, because they had to convince Twitter of the identity. And from a legal perspective, the difficulty was that Twitter doesn't maintain a legal presence in Australia. So that meant that the Australian lawyers had to engage US lawyers in order to get the court proceedings served on Twitter's registered office. And Twitter being outside the Australian jurisdiction, it created all sorts of very practical and very real difficulties for the CBA in being able to essentially gather enough leverage to shut it down earlier in time. They then had to prove that the identity had been hijacked, and that there was a contravention of Twitter's terms and conditions. And by the time they finally regained the high ground, so to speak, the damage to the brand was out there. It had been circulated, and that damage was to the effect that I think it was tweets to the effect of the banks are really only in it for themselves, and was purportedly, as far as the rest of the world was concerned, coming from a senior executive within a CBA subsidiary. That's just one example. We've also seen in recent times attacks on high-profile celebrities, which does raise serious potential for criminal liability for individuals behind those attacks by reference to the Commonwealth Criminal Code.
Yeah, and we'll come to that in a second. Not wanting to steal one of our key points in about 5 minutes today. But the key thing, obviously, is that, and you know, there are legal implications. But one of the key things I'm finding is that there is we talk about business owners having a bit of an attitude of ignorance. I think there's also maybe a lack of ignorance or just a pure lack of respect where a lot of people are using these channels and saying and typing things that, in a face-to-face situation, they wouldn't do. So I think it's clear now what we're seeing is that the law is starting to pay close attention to this because ultimately, as you alluded to, and I want to come back to the point, there are some legal ramifications. But just had a question posed actually for you, J.A., and obviously I know you're a partner with the firm and you're a lawyer, so you need to be careful about giving specific advice. But the question is, should you respond to somebody who's decided to attack you online? It looks like it's malicious. What are your thoughts on that? What would you normally recommend at a high level, first steps?
Look, from a very high level perspective, at the risk of sounding like a lawyer, it depends. I think there is the potential to inflame things if there is a response, and I think the first thing to do is to actually properly assess what the comments go to part of, make a quick judgment call assessment of is this seriously damaging to company brand, personal reputation, company reputation, and then if it is, you probably need to start considering whether you want to get some advice and take the matter further. You can obviously bring it to the attention of the service platform because many of these service platforms have terms and conditions of use, and in many cases, flaming and trolling sits outside terms of use, so you can appeal to a moderator to have those comments removed, and that's not a bad first step. And it certainly helps to have that paper trail in place before you perhaps start walking down the street to the lawyer's office to take a sledgehammer approach.
Yeah, look, this on the screen at the moment is I've logged into the Twitter Help Centre, and I've just got the page there showing what steps you can do to report abuse or policy violations. And what I will do for everyone at the end is I'll actually share a couple of links for the audience, which actually take you directly to these pages on the Twitter platform. And as quite a few people on the webinar know, and as you know, J.A., I do use Twitter a lot, and it's I'm always intrigued when people say to me, "You don't know where to go or how to actually report abuse." And I was amused in that CBA article that one of their early struggles was they weren't sure where to turn. So the first thing, obviously, I always recommend is jump on these pages, and if you need to raise a claim, so at least, as you said, you're starting a paper trail to actually go back and be able to see that you're taking action. So
yeah, so absolutely. And I think if I can just quickly comment,
sure,
where the CBA had particular difficulty in that case was it revolved around the suggestion that the Twitter account was being operated by a fraudster, essentially someone else, and Twitter was in the invidious position of trying to determine, well, who do I believe, and how do I know that you are a representative authorised by the CBA? I think that was probably one of the difficulties based on nothing but experience that was probably encountered.
Yeah, and I'm sure we'll hear more about how that was handled. So the one of the key areas I've kept an ear to the ground on, JA, is the fact that companies may actually look at this as an opportunity to disparage or to potentially attack a competitor. And there's been some stories recently where it's been felt that in the sports arena, for example, that some competitors are using channels like Twitter to attack the competitors and throw them off their game. So this is a really interesting area because it's as we've seen and we discussed yesterday, the Greenpeace Shell situation was a classic case where Greenpeace launched a campaign and essentially parodied one of Shell's marketing campaigns and turned that on its head and were almost able to impersonate or con an audience into thinking there was an official Shell message going out into the marketplace. So it's a fine line now between parody versus impersonation and doing real damage. So.
And look, that's absolutely right, Mark, and that does give rise to a number of particular legal considerations, and I'll use the Shell example first in mind. The first thing that springs to mind is there's an issue of trademark infringement because what they did there is they took the Arctic division of Shell, put it on their rival website, as I understand it, and also took the very well-known Shell logo itself and stuck it on there. They were not authorised to do that. And as I understand it, that is the subject of some pretty heavy-duty serious litigation.
Well, it's Shell, as we saw with the US Gulf oil situation, where believe it or not, their internal PR team suffered because somebody started parodying their PR account as an official Shell PR channel, which caused grief as well. And look, it's happened to Qantas. We saw somebody set up a fake CEO account and has been impersonating Alan Joyce on Twitter as well. Fortunately, that person has a pretty impressive sense of humour, but ultimately it does hit directly at the whole reputation, brand damage situation, which we're all very conscious of. So,
yeah, look, absolutely. And the other aspects, going back to your reference to the sporting arena, is people, individuals in particular, and indeed anyone who encourages, aids or abets an individual in those sort of attacks which are aimed at really harassing others, should be mindful that criminal code there's possible criminal liability there for using a carriage service to menace or harass.
So, not wanting to tell you law, but from memory, that's covered by federal acts.
Yes, that's the Commonwealth Criminal Code section.
Okay.
74.
Not one you want to mess with. So listen, what we're seeing here, we're seeing a couple of situations in Shell, Greenpeace, the CommBank, where it has been external, what we believe to be external parties doing things that are less than savoury. One of the key things that I think we've got to be very conscious of, and this is, I guess, really at the heart of employer concerns when I talk to CEOs, they're really worried about something blowing up internally because not all these risks come from outside the organisation. And as we were discussing, Vodafone in Australia were really shaken recently with the situation of a Vodafone staffer losing the plot on Twitter and Facebook and essentially doing silly things. So, the challenge we've got now is we've actually got to think about somebody inside the organisation, going native on you and essentially doing damage here. So, Vodafone's in a pretty tough spot here.
Look, again, absolutely right, and the employment, which is my predominant area of practice, is rife with employers doing their level best to come to terms with the social media tools and then to discipline staff who, in the employer's eyes, have misused it or And the Vodafone story is one of those examples. And I have just a very broad observation about the trend of decisions coming out of Fair Work Australia and other jurisdictions about what is the tolerance level there. That one commissioner recently was quoted as saying it's foolish for employees to think that they can publish comments without any fear of the consequences that might follow. So I think that's a key take-home message for employers that if you do have staff who are engaged in using these mediums inappropriately, whether that be to harass others or make comments that negatively impact on the viability, the profitability of your business, it's potentially actionable. But herein lies the rub. You're going to be on less solid ground if you don't have in place and if you can't show that you're engaged in some training as to what you regard as acceptable use and non-acceptable use.
Mm. So this, we look at that Vodafone situation, and the person had put themselves out as being an internal social media expert, which clearly you could argue that misrepresented their competencies. The Charlotte Dawson one, you touched on this earlier, hit the press, and the press picked it up in a big way. It was a pretty tough situation for anyone to go through. But the reason I want to come back to this, JA, is because what has been identified is that the person who launched the initial trolling attack on Charlotte Dawson was actually employed by Monash University. So this has dragged Monash into this whole mess now because, they've identified a person who was doing something on their own time, but left enough breadcrumbs there for people to track the person back to one of our top universities. So, is there, obviously I doubt there's legal recourse for Monash, but it certainly is causing some reputation issues for them. So.
And look, that's absolutely right. And the difficulty for Monash was making that judgment call about whether that conduct for them to take disciplinary action or be able to do anything, because there's that blur that you mentioned at the start between, well, what's private comment, what's the right to free speech, free expression versus what limits can be imposed by an employer. And look, I think for the benefit of our listeners, it's worthwhile just making these three very quick points. The law is actually pretty clear on this, and it simply is clear, and that is the conduct has to cause serious damage to your relationship of employment. It's got to damage the employer's interest, to be incompatible with the employee's duty as an employee. So that arguably extends to if people are expressing opinions that are not in keeping with the mission statement, views and values of the organisation. My personal view is that as an organisation, you've got a right to ask yourself, do I really want such a person inside my organisation in the first place? I don't think it's any complicated than that.
Yeah, look, this is, I guess, JA, this is the big thing people are struggling with is the fact that, we have seen employers have rushed in and simply said, that's it, you're out, but have found themselves in a whole world of hurt around unfair dismissal. So, interestingly, JA, I'm just watching the audience, and we've gone from everyone's paying attention at the moment. This is a pretty key point that everyone is concerned about. But so you just made a couple of points here about the position of the law. You're saying it's pretty clear. The first point you made was if the conduct causes serious damage to the employer.
That's correct. Or the relationship of employer.
Okay.
What I mean by that is that it's sufficiently damaged that you couldn't continue to have trust and confidence in that employee's ability to remain in employment.
Okay. Okay. And in terms of damaging the reputation or the image of the employer, you're saying they can point to that, saying it's caused considerable embarrassment and reputation loss for the employer?
Yes, I think that's a very good summary, Mark.
Okay, excellent. Good. Now, that's a key point. As you and I have discussed, I think we're only at the very beginning of, how this is going to evolve. I think, unfortunately, we will probably see many more incidents where employers are forced into a difficult situation. And one of the, from talking to TEC members around Australia and New Zealand, I've heard some difficult stories, and the key thing I stress to business leaders and employers is that you need to take action, because it can in fact suck the life out of your business. You can end up with key executives sidetracked dealing with non-productive issues. So it's key we take action on this. So good summary there. I just want to change up for a sec and talk about this other area, which is involved in what employees are doing, how they're managing what's happening online, because we've now entered this world where we've got to start thinking about, are we being social as a brand or as a business, or are we just doing more advertising? And the key thing that we've seen, I just want your perspective on two things. One is the Smirnoff case, Smirnoff being the vodka brand, and the other one, which I wasn't aware of until I read the article you wrote about allergy pathways. So I wonder, could we start quickly with Smirnoff and Facebook? So.
Yeah, I think it's another excellent example. We've just seen very recently that the Advertising Standards Bureau handed down a decision where fans had been posting comments that, amongst other things, were racially derogatory in nature, offensive generally, and in that case, and this is the key take-home they said, look, really, we expect you platform to be moderating, and we expect you to become aware of these things, that you will take them down within 24 hours of becoming aware. It's a difficult scenario, because it then raises this question for organisations of, well, can I afford to employ someone in my IT department who sits there 24 hours, 7 days a week, doing nothing but scanning and moderating content on our Facebook site, our Twitter account, MySpace, YouTube, you name it. Pretty difficult, notwithstanding there's a lot of software out there that allows you to monitor for keywords.
Yeah, look, I guess the other perspective here is that we've actually got to think about, and I had this discussion with a colleague in Melbourne, that one of my issues with Facebook is that your options as a person managing a brand page or managing it for your employer, you literally have two options. You can leave it or you can delete it. And unfortunately, Facebook doesn't give you the option of taking something offline whilst you classify the situation or potentially ask them to remove it. You simply have to delete it, and it's unfortunate that that's the only option you have. But I think it's critical as well that we understand that once you set up a brand page and start communicating, there is a degree of responsibility, and the law has now said this is how we're going to assess you in terms of if something is breached or something inappropriate happens. So sorry, go on.
Can I just make an observation, Mark? You've just prompted my memory about Coca-Cola's experience with Facebook, which kind of point. Coke discovered that two of its legitimate fans had set up a Facebook page, put their trademark logo on it, and by the time they discovered this and made contact with Facebook, the site had literally millions of followers, and there was nothing particularly damaging by way of post there. So rather than take a pure legalistic approach, they engaged with Facebook, got an introduction to the two creators of the page, and ended up contracting them to continue to run the page and maintain their brand, probably deepened their market penetration by putting on board, who then legitimately posted comments saying how pleased they were with Coke getting them involved.
It's a good story, isn't it? So, there actually, I know of a local example of that too, JA, where in fact it was actually a TEC member based in Adelaide, Hague Chocolates, quite a well-known brand in South Australia, and they've got a store opposite. Trying to think of where it is in the Sydney city. What happened again? They had a person who had set up a Facebook page and had built up a substantial fan base, and they basically wanted to take control of that part of their online reputation. And they actually did a deal where that person provided, handed over the ownership of the page. But they supported that person, and they provided some, let's say, it was sweet inducements for a period of time for that person as a reward. So now, just quickly, we've had a question come in from Peter Black, and Peter didn't use the webinar portal to ask a question, because those of us who know Peter know that he will have asked a question via Twitter. His question is, what is the responsibility of, say, a pharmaceutical company if they're monitoring a non-company site for adverse events? So I guess in this context, take a pharmaceutical drug brand is looking at an online forum, and they're finding that there's people there starting to post inappropriate adverse comments, potentially even giving advice when they have no right to give advice. So what are your thoughts there?
Well, I think first thing is to obviously capture the evidence, speaking as a lawyer, whether printing it, capturing it photographically or otherwise, and then I think you'd be probably looking, subject to what that content is, to communicate with whoever the appropriate entity behind it is, and ask them to moderate or remove that, so get that trail in place. And subject to your perception of how damaging it could be to the brand, some other strategies to consider is to perhaps identify on your own authorised site attributed to the organisation on site X are not authorised and not the comments of this organisation, and essentially disclaim any responsibility for anyone who places live. You'd be doing that simultaneously, together with escalating the matter accordingly if you needed to, by way of takedown notices.
Okay.
That's one option. You then obviously there is the potential for getting the authorities involved if the comments are in that harassing or menacing way, or pitched in that way, proving that. So if it was a sort of an act of intentional industrial sabotage, which could be difficult to prove, formal remedies through the authorities you can consider as well. I hope that's answered that question.
Yeah, no, that's good. And look, I just, in the interest of time, obviously Allergy Pathways, in summary, they've found that it has been aware of essentially false comments, false testimonials, and took no action until, was it the ACCC put some orders in about their actions. So the key thing here obviously is that they became aware of, essentially, inappropriate, misleading comments. Took no action. They were able to prove that they're aware of them, and the ACCC took action. And if anyone is interested, I will, of course, post a link because, JA, you did summarise that very nicely on the article you wrote on the Gadens site. So I'll actually put that link up for people to have a read of as well. So,
yeah.
So just quickly, JA, clearly there's some implications for business. Again, you wrote this a couple of weeks ago talking about what does it mean for our business. The key thing I think at the moment is that as an employer and as a business owner, we've actually got to think about not just our own content, our own employees, but we've now got to be very wary of third-party content because we can't sit back and say, well, no, that's somebody totally disconnected from my organisation, therefore I'm not responsible. So,
yeah, I think that's right, Mark. I think it's one thing to do the basics, and the basics are terms and conditions of usage in employment contracts, policies, and educating and training. I think making sure that the people who use social media to reach your target market, your people who are in charge of that, know their way around the ballpark and are the right people, they're responsible, that their values are in alignment with the organisation's values. And I think something that gets overlooked a little bit in the current climate is with outsourcing of IT, you need to be looking very critically at your procurement contracts in relation to, well, if you're using cloud computing to manage your database and that's how your information works, or through some third-party provider, you need to make sure you've got very clear, very expressed rights in those terms to take control and get things action goes to shape, as they say.
Yeah, look, I've argued for a long time, JA, that I get very frustrated when business leaders, CEOs say to me, oh, we found a bright young thing in our office to do this for us. And I think bright young things probably know their way around devices and some of these social channels, but and not wanting to be disparaging on that generation, but I think we've got to be very conscious of business acumen and also ensuring that the person understands what to do when something starts to get out of control. So have you actually put an escalation plan in place? Have you actually educated and trained them on how to not get emotionally wrapped up if somebody goes off the deep end and be disconnected from the emotional response versus the business response. So I think that's really really important point. And one of the key things, obviously, still amazes me, particularly on Facebook. I see a lot of big brands now don't have guidelines. Just one of the conclusion points here is that if we're using Facebook, you need to set out the rules about what people can and can't do, and what you will do if they do something inappropriate. This caught Westpac quite badly a few months ago, and look, probably the best example I've seen is Scania, the European transport giant, on their Facebook page, and you can see they've got over 130,000 likes on the page. They have a tab here called House Rules. So if you want to go to the Facebook page for Scania, they've actually set out quite clearly what the house rules are, and if you breach these house rules, they actually tell you what they will do in response. So that's I think that's the key thing that I see a lot of people overlook is that where do we have guidelines in place, internal and external. So now, just last quick point. There's a couple of questions I want to loop back on, but we've discussed this. We're both on the same page, but the education side of it, so we can put guidelines in place. Clearly, education is the next great requirement for companies now. Actually making sure we provide a proper education for staff. What are your thoughts on that?
Look, absolutely right, and like any compliance regime, there is a need to be able to demonstrate if you are in a contest, in a tribunal or a court, and if you want to be able to really guide people and ensure you don't have issues, you've got to train them. So that means using a number of different varieties of training. It can include, obviously, attendance at seminars, making use of webinars, in a pop-up screen when people log in, saying, reconfirming that they accept the terms and conditions of use of your policy. Because there's nothing worse than being a lawyer standing in a court trying to argue that you're justified in action when you can't connect the dots. And what I mean by that is proving that the individual who was ultimately found to have made the post knew what was acceptable or unacceptable, and despite that, didn't apply. I've come unstuck many a time where clients can't show me the link that shows they've signed off on the policy or they knew about it or were inducted in it. It's a real personal bugbear of mine. I appreciate, business comes first, and not all organisations are equipped or have the luxury of the budget to do that, but I do think there are a variety of for courses, if I can use that analogy, for different sized organisations to adopt.
Exactly, and look, I was just thinking there couldn't be anything worse than having a cranky lawyer who's on your team, could there? So, look, there are some simple things companies can do, and there's a wealth of online resources around guidelines and policies. And the one I've had a lot of time for over the years is the IBM social computing guidelines. And the reason I like it a lot is because it actually talks a lot about the culture of the organisation, which I think is important and it's often overlooked. Is that we've got to be very conscious that we are reflecting the culture, and if people are going to misbehave or do silly things, it can also mean that they're not part of the culture of the company, which means you're potentially getting an indication that maybe it is time to help advance their career somewhere else. So now, J.A., just quickly, questions come in about wanted just to recap again on that work time versus personal time. I said it was a big topic, and one of the attendees just wants a quick recap there on those points we said before about the position of the law if somebody feels they're on their own time. Probably more importantly is it is a bit grey around what is work time, what is personal time. So what are your thoughts on this area about, when can we actually deem somebody might be at home, but they theoretically are acting as an employee?
Yeah. Can I just have a minute or two to comment on that, because there's a little bit that's involved that I need to get out. First observation I'd make is that Fair Work Australia, other courts and tribunals are making it clear that they appreciate that what has to really truly be appreciated is once a comment's made by way of post, it's there until it's taken down. So if it's made outside of work hours, it's still there when they come back to work. Mm-hmm. So if it's a comment that is, for example, Del Ray and Real Insurance, where the comments were extremely critical of actual management, critical of co-workers, and were offensive or abusive as some of the other cases were. That's in the realm of inappropriate conduct, because you're in the realm of bullying, harassment, etc. And even though it might have been made outside of hours, it's actionable because it tends to bring into repute the employer's reputation, and it creates conflict in the organisation, and that is not consistent with what the law recognises as the traditional duties of employees. And more broadly, under the new safety legislation, there are very specific obligations imposed on employers to ensure that people will have a right to call their place free and safe from this kind of harassment and activity. Other things, just quickly to mention, to look at are, when you're assessing this scenario, ask yourself, if the content was posted after hours, was it posted by use of the employer-provided internet or communication network? So if you have remote access as part of your organisation's flexible working arrangements, and they've used the company-supplied laptop, the internet paid-for connection to make the post, that's going to be sufficient to ground a connection. Where it particularly tends to attack or identify co-workers, management, the particular brand, it is likely to be actionable. And as I said before, it has to be conduct that is damaging to the employer's interest. An employer has an interest in maintaining harmonious workplace relations inside its organisation. You can't be expected to be getting in the middle of something when they pop back into work on Monday to manage something that's happened offline. That's just, in my humble opinion, puts too much of an obligation on employers. And I think there is a bit of a connect, though. I do have to say that.
Yeah, no, that's excellent. It is a big issue, and what I'll do is I will post a bit of a summary for you. Now, listen, Jay, thank you. In the interest of time, we've got a couple of minutes over, but I think we had some questions coming in and some nice dialogue on Twitter as well. So thank you for your time. I really appreciate you contributing. And if anyone's interested, we are doing the session again tomorrow morning for quite a few more people. So but if you're interested in the Executive Connection, you can find out information online at tec.com.au. If you'd like to ask any follow-up questions, we actually are doing that via LinkedIn. And what you'll find online there is actually a discussion there where if you want to post any follow-up questions, you can actually join us there and we'll be answering questions for the next little while that may have come out of what we've discussed. And finally, we will be posting via TEC, posting the content, the recording of the webinar, posting it into SlideShare, and TEC will be sharing that out as well. So once again, J.A., thank you very much for your time. It has been a fantastic discussion. I've enjoyed bouncing around this issue with you. And based on the level of attention we've had, I think the audience has been very well engaged as well. So thank you, and I hope you have a great afternoon.
Thanks very much for the opportunity to be part of it, Mark. And look, if there are questions more properly in my area of the world, you'll find my details on the website, and feel free to pick up the phone without fear of thinking that the clock will necessarily be on.
Good man. I think the TEC community certainly appreciate that. Thank you, Jay, and thank you everyone for attending today.